So it's definitely on the boom. It's a good field right now.
Still am. So our firm, we're a big law firm, but we're kind of at the bottom end of that, right? And we tend to focus more on mid-market businesses than the Fortune 100 or Fortune 500, although we have some clients that are in there. And so it gives you then, and we've got companies that are 120, 130 years old. We have startups that just came into being in the last year and a half. So there's a very broad spectrum of issues that they come across. And so you really have to develop a sensitivity to certain sectors in your client base. We have a huge healthcare practice. We have a huge government practice. Government is way behind the curve on this and has some big issues regularly with this, although certain segments in that, public agencies, are doing a good job. And so it's really, the kinds of things that, there's some companies that have no awareness at all, and you have to become their guide and let them know that while they have no operations in Europe, and they really don't touch there, they're doing business with companies that do, and those companies are starting to push down into their supply chain. And so again, do we really have to do this? Do we have to meet the GDPR as part, as a processor, as part of a contractual obligation to a critical client of ours? And on the flip side, you've got the global organizations where the InfoSec guys that I tend to trend towards are saying, they're telling us we can't use this monitoring tool because it's surveillance and it's going to fall afoul of our new obligations. Or we're only going to roll it out in the US because we can, but we're not going to put it in Israel or Singapore or the EU. So it's trying to balance and help them frame. Because the biggest problem you have if you're an InfoSec guy is having 3 different rubrics of what you can or can't do to respond when there's an incident, right, of whatever type. So you want to try to make that as routine as possible because they have to react quickly, but there may be things that they're not allowed to do on the front end, and advising them of the risk of implementing that kind of functionality.
Yeah, all great comments, and resonate certainly with my personal views and my practice. Kate's comment about working in a tech company in Silicon Valley, I think was really interesting. The engineers that I work with, the product people that I work with, the business people that I work with, by and large, they just want to do what's right, and they want to be told what's the minimum that I need to do here. That's actually the question that I see the most. Some of that is because they want to do less work, right? They want because I could tell them, well, use this type of encryption on this system, and that might reduce the actual operational viability of that system by 30% instantly when you turn it on, right? And my view as a more risk-averse lawyer in that situation would have to say, well, it's the best, right? It's the best way to protect yourself here. But we need to work together to make these risk-based trade-offs. So I see the questions in my practice coming up pretty pragmatically. I think there's a big awareness here in Silicon Valley. I have no idea what the awareness level is around the rest of the country and the world. I can tell you I got into the information security business by negotiating data security terms in commercial software licenses. That's how I got my first exposure to it. And the Silicon Valley lawyers that I would deal with knew what they were doing, by and large, and the ones sort of outside, they would get there, but it would take almost the whole negotiation to get them there, and I found I'd have to put somebody on the phone, to educate them, where we're like trying to educate the other lawyer about how this is working, or otherwise they would just appear to be obstinate, like they don't want to move off some position, but it was because they didn't understand, what was at stake. So I think, it's kind of an interesting time to be a lawyer. And the comment that I would make here is that, all of, the practices are actually represented here in the business context, right? We've got 2 in-house lawyers and we've got 2, outside lawyers who deal with all kinds of companies. We heard healthcare, we heard, startups, we heard well-developed, more legacy type companies. Basically what I think we all need to understand as lawyers is that the clients we serve are actually experiencing a complete digital reorganization to survive. And so even if you aren't working with a tech-focused company, that non-traditionally tech-oriented company is now becoming, whether they want to or not, a tech-focused company. They have to have a public-facing website presence. They have to go do digital marketing and collect information on their customers. They have to, move all of their, credit card processing into some cloud-based PCI compliant system or whatever, right? And they may not even be developing software traditionally how we think of tech companies. So your clients, I think, are going to increasingly be thinking about this. And so, the next part of our panel here will be talking about the things we can do as lawyers to help serve that groundswell of need in this area, even if you're not a data security or privacy expert. So here are some ways you can kind of think about how to handle these things going forward, and we'll look at it through sort of the ethical lens.
Before you leave that, though, I want to follow up on a comment you made about other lawyers and just share with you an experience I had. We were negotiating a cloud contract, and the lawyer was in Massachusetts, and there was a clause that called for the confidentiality, integrity, and availability of the data, the classic data security triad, right? That's what you're trying to protect. And they objected to the term integrity, and the reason they objected to that is because they were adamant that they would keep the data as it was given to them, but they didn't want to validate that the data was correct. And I'm trying to explain, A, this is not contract language, this is a reference to a standard, and that's what the standard is called, right? And B, we're talking about however we give you the data, whether it's objectively correct or not, you're going to keep it that way. You're going to guarantee that it stays that way. And that's the kind of argument or discussion or debate that you can have if you're dealing with someone who's not experienced in this field. It's literally that simple. And ultimately, the client said, just leave it out. It's a business decision. You know what it means. We know what it means. She doesn't know what it means, so it doesn't matter, And I don't mean that in a pejorative way in any way. That's just the fact of it. And so that's what we went with, right? It became a business decision. But at some point as a litigator, at something I might litigate over, if there was a breach that related to integrity of the data, it creates enough uncertainty that you might be able to leverage that.
Great, thank you for that follow-up anecdote. That's another great illustration, I think. So we'll go right into the ethical considerations and the ethics component of the presentation. So hopefully you're all excited to get some MCLE out of this. I know my ethics credits are always the ones that are like the hardest to find, because I always want to find one that's like actually interesting. But so anyway, we'll go right into it. You could do a whole panel, whole hours-long discussions on either or both of these duties, and hopefully we're all very familiar with them. These are the duties that are literally the background duties that define us as professionals. They're the ones that are like little kids tugging at your sleeve, right, constantly. Like, am I doing these two things, and how is this working for me? So the competence, duty of competence. There are the references to the rules for both ABA and California. We could go deep into this, but I just want to focus everyone on the core language that's basically goes across both those rules. Is that we need to be diligent, we need to be prepared, we need to have the skill reasonably necessary for the representation. So we're going to talk a little bit about what that means when data security. Both when our clients are experiencing these issues and we're advising on them, and both for our own practices. What does that mean to be competent in the area of data security? And then the confidentiality, this is often dovetails in some of these ethics opinions we'll look at. they're usually together, because your lack of competence in the security area usually leads to some sort of disclosure of your client's confidential information, which you've agreed to, preserve with, in a reasonable way, based on what the information is and how it's related to the representation. And you're not supposed to share it without the consent of your client, with some limited exceptions, right? And that's a whole nother talk, right? But those are the two background rules that I just wanted to kind of set up, and I think everybody's familiar with them, but we'll kind of go in and explore them a little bit in a little more detail. So we're going to do this one like Jeopardy style for the panel. So I've got 3 categories up there. So in terms of competence considerations, we have sources of law, because this is an area that I think we've touched on already, has a lot of the classic patchwork, who knows where the actual source of law is coming from in any given situation until you really do a square search for it. We could talk about data security frameworks, standards, and guidance, how that can be useful for both our clients and us. We could also talk about ways to develop technical competence as a lawyer. So I don't know, Josh, which one would you like to start off with?
I'll start with sources of law for 300.
Yeah, that sounds good.
All right.
That sounds good.
So this is actually a really good question. Like, where do you find the sources of law when a client comes to you with like a data privacy issue or a breach or whatever? That is a really hard thing to answer. I start always, and this is not where I end, and I always verify. So this can be like really controversial, but this is really where I start. Wikipedia. Why Wikipedia? Because it gives you a general understanding of whatever you're dealing with. Because I deal with really strange things. Like, I have a bunch of confidentiality, so I can't actually explain to you some of the things, but we'll say hypothetically, okay, I've come up with this new piece of technology that uses data in some really weird way. Well, I don't even know what that means initially. So I go to Wikipedia and I start looking up, okay, I know what those words mean. Then I go, okay, so this was invented here. And I get a basic understanding of where it's going to be touching and concerning. Then I'll do whatever the major country is. So it's like, if it's the United States, I'll check out the FTC because they're really good about stuff. That's the Federal Trade Commission there, just in case people are listening. Local states, California's really good about a lot of things. I definitely will call my friends. When I'm dealing with international, that gets a lot more difficult. It's easier now in the EU. The EU, if you just go to Europa, is it Europa.com? Europa.eu. Thank you. Not .com, I'm sorry, EU. That's a great place to just check and start. They're also really good, even if you're dealing with non-EU. They've got a lot of good resources online. Google searches, but it's really, it's not so much a specific thing that you can check out. It's just you need to do that research. It's like you got to put time in the seat on the keyboard checking things out.
And I would just add to that, especially in the international realm, like what's on the books is not always helpful. Like you can find the law in India, and that's wonderful, but they've never enforced that law. So really going that next step to see, like, yes, that's great that there's laws and they seem very robust and they seem very scary and implementing a lot of requirements as a result, but 9 times out of 10 in a developing country, those laws are never enforced, especially against international organizations. So figuring out the places and points of contact that you can find out the enforcement history as well is huge.
That's a really good point.
Yeah, I've got Everett, so if it's EU, I just call Everett. or government, right? The other thing that I try to keep in mind and actually have at my fingertips for clients that are repeat customers is just understanding, I start with, are they a regulated business, right? Because that gives you, first of all, often an out. So if you're a HIPAA entity, right, covered entity, then all of these other rules don't necessarily apply to you. They're often embodied in the law as an exception. And so are they a covered entity? But is there a regulatory framework? And then are they a public company versus a private company? Because you've got that overlay of obligations that public companies have that private companies don't have. Where do they do business, right? Where do they touch? Where are their clients? And all of those things vector you into where you need to look to, not, you may have a good sense of what the law is if you've been doing it for a while, but to get the latest and greatest information. And then I have a ton of feeds that feed on both privacy and you know, I'm a SIP, I rely a lot on publications and resources with the IAPP.
IAPP is really good.
Yeah, I would have to agree with that last comment about the IAPP, International Association of Privacy Professionals.
Yes.
I think that's right. I'm terrible at the acronym. I'm a member, but terrible at understanding the acronym. But anyway, they have awesome resources, and there are other really good resource kind of subscription services that I don't know if your firm or your in-house legal department would pay for, but like Gartner or CEB, they have these subscription services with big pools of resources that have all kinds of cool things like data protection policy samples from other clients of Gartner's or CEB's that they were willing to share and post, right? So you can see kind of like what another very large company or medium-sized company or really small company decided to put in their documentation for some of these source of law issues, and what do they feel governs their business, and how are they documenting a particular response to a regulatory issue in writing, right? So that you can look for sources of law there, or kind of near proxy interpretations of those sources of law. So those are other good places to look. In terms of, we're not doing Jeopardy anymore, so I'm going to tell you guys. The next one is ways to develop technical competence as a lawyer, because I heard Wikipedia. So this, I go to Wikipedia a lot for basic technical understanding.
Doesn't that feel good to admit?
It does, for sure. But it's a really interesting starting point. And it is also, if you're very careful calibrating yourself to a Wikipedia article, I think you can start to understand which ones are, probably more well-sourced and well-written and well kind of maintained than the others. And so that is a really interesting place to start. But here's we'll take that last question for the panelists, and then I'll compound it. I'll add another question. So what ways can you develop technical competence? And then do you now view that there should be like an emerging standard for basic technical knowledge and skill among all lawyers? And if so, kind of where does that go, or where does that lead us?
I mean, I definitely don't think we need another certification body or more initials after our names. There's enough of those making money off of us these days. But I can't stress enough how important it is to really understand the technical nature of the work you're doing. Not only obviously as a ethical duty as an attorney, but more importantly because your clients won't call you and won't trust you if they don't think you get it, if you can't meet them where they're at. If the IT team brings an AWS instance question to me and I ask them what does AWS stand for, they're never going to ask me that again. So very basic core competencies to build that trust and to kind of get your foot in the door and make sure that the teams are including you as they need to is really important. And I don't know that there's a one-stop shop. I find that conferences are really helpful. So you may not be the most popular person in the room, but go to RSA, go to DEF CON, show up at Black Hat, and just sit in, understand, ask questions, in that kind of an anonymous environment, and really soak it up, because you need to be able to communicate in the language that your clients are communicating in to not only understand the risk, but give them feedback that they can apply. So doing things like that and really making sure that you take the time to Coursera a course on cybersecurity, or read a book about it. These things aren't complicated to find. You just really have to spend the time and do it up front to make sure that you're being able to offer the advice and information you need to.
That's a really good point about conferences being a great place to get technical expertise without really diving in by yourself on a computer. One area where I get a lot of my technical expertise is from my clients. I have been experimenting over the last couple of years with all-you-can-eat legal fees, where I charge a fixed fee, and that lets my clients actually talk to me instead of worrying about every 10 minutes whether or not I'm going to bill for asking that question, so I don't get yes or no to technical questions. So that's a really good way of getting to understand your client's problems and issues. And it's also a very good way to build up rapport with your client. So I have other ones, but that's probably the one I want to focus on. Talk to your client.
So I agree with all the sentiment. I would start out by saying that, Kate, you don't need to worry because as a profession, we're a self-regulated industry. Is my microphone on? No, sorry about the other room. But, and so, we always have the out that we either acquire the skill or we hire an expert or we decline the engagement, right? So I don't see, the bar is what regulates us. There doesn't seem to be any sentiment at the ABA or the